Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please.
Good morning, all. Before we hear arguments today, I'd like to recognize for the court that today marks the last argument sitting for our dear colleague, Judge Tatel. Judge Tatel will be retiring from service on the court after nearly 3 decades, during which time he'll have heard argument in close to 2,600 cases. Advocates in those cases will have experienced both the privilege and the challenge of appearing before him. As someone who had that experience, I can attest firsthand to both the privilege and the challenge. On behalf of Judge Millett and all the members of our court, we extend our deepest thanks to Judge Tatel for his model and his inspiration and for his partnership in pursuit of our common calling. Our court and the nation are extraordinarily grateful for it.
Well, thank you, Sri. Based on my calculations, other than on banks and complex cases, I think this is my 750th or so sitting in this courtroom. And I'm confident, Sri and Patty, that it will be the best. Thank you. Thank you very much.
Of course. Ms. Rothenberg, please call the first case.
Case number 21-3075, United States of America versus Eleanor R. Milligan, appellant. Mr. Hicks for the appellant, Mr. Hahn for the appellate.
Good morning, counsel. Mr. Hicks, please proceed when you're ready.
Thank you, Your Honors, and may it please the court, George Hicks for appellant Eleanor Milligan. There is no dispute in this case as Ms. Milligan never put intent or mistake at issue. As her counsel candidly told the district court, quote, "We are not contesting intent or lack of mistake." And he added, quote, "It's just not a live question." Accordingly, the 404B other act evidence regarding Ms. Milligan's uncharged conduct that the government introduced specifically to establish intent and lack of mistake had no probative value. And like all 404B evidence, it was prejudicial because it conveyed to the jury Ms. Milligan's propensity to engage in the conduct that was actually charged. But the prejudice was even more pronounced than in a typical 404B case for several reasons.
What do you do with the, you quote what counsel said at trial, but pre-trial, the district judge asked if he was prepared to stipulate intent, and he said no. He said very clearly, he said, quote, "Let me be very clear. I'm not stipulating to intent or lack of mistake."
Your Honor, counsel made that statement during the pre-trial conference when the motion was first being heard on July 9th. Later, during trial on July 21st, he made very clear that they were not, Ms. Milligan was not contesting. He said, "We're not contesting. We're not making that argument. It's just not a live question." And I think the salient question for purposes of this analysis about trying to determine what the probative value is and what the prejudice might be on the other side of the balance is whether the purpose for which the other act evidence is introduced is actually at issue. The Seventh Circuit makes that very clear in its Gomez case en banc, where it says an important issue in the Rule 403 balancing is the extent to which the non-propensity factual proposition actually is contested in the case. It later says the degree to which the non-propensity issue actually is disputed in the case will affect the probative value of the other act evidence. And I think even the district court understood that on July 21st, because he doesn't phrase his decision in terms of there being a formal stipulation or not. He refers to the defendant, quote, passing on contesting the issue in a live way at trial. And I think that makes the difference here, at least when you're looking at the probative value. I mean, the government's motion was premised on the proposition that intent and mistake were at issue. And by the time of July 21st, it was made clear to all, both the district court and the government, that that was not the case. She was not putting on a defense.
What do you mean? I mean, no criminal defendant has to put on any defense at all. But that doesn't mean that the elements are not at issue and that they have to be found by a jury beyond a reasonable doubt. And so intent was still, or the mens rea was still very much at issue, and that the government had to prove it beyond a reasonable doubt to each and every single juror.
Well,
so
certainly,
it's still a live issue. It's very much a live issue with a very heavy burden on the government.
Well, certainly it's still the government's burden to prove all that, but that would be the case in any situation where you've got 404B. And so I think that that would not be entirely consistent with the cases that say when the other act evidence is used for a purpose, whether it's
no, but it's been used
not at issue.
The probative need remains from the government's perspective, from its burden. The need for probative evidence to establish intent remains. So I don't quite understand saying intent was not a live issue, just that the defendant chose to stay quiet on that issue.
Well,
There's no stipulation to hand to the jury.
There's no stipulation, but I think that when you're trying to determine the marginal probative value, which I think really is the question here, it's not simply sort of probative value, probative value, it's the marginal probative value of that other act evidence over what's already in the case and what the government would need in order to surmount some sort of defense that raises intent. And I think that's shown by the government's case.
That's a different argument. That's a different argument, that there's what evidence is already in the case. But I was struggling with it's not a live issue, and what it seems to me it very much is. But the marginal probative value relative to other evidence in the case, it feels to me like a different argument than just saying something's not an issue, a live issue.
Well, I think when you're trying to determine what the marginal probative value is, you have to look at the extent to which it actually is contested in the case, beyond simply, well, it's an element, therefore it's always at issue. I mean, I think that's clear from the cases the government cites, almost all of which involve the defense putting on a defense. So
there was evidence before the jury that went to the question of mistake. It came from the government. The government put it on, but at least the government introduced testimony that raised it. But there was evidence before the jury from which the jury could have thought about the question of mistake.
I think there was one passing statement that was, as you say, put on by the government. So it seems a little backwards to me that the government can put on testimony that somehow allows them to then put the.
But you don't think that the government put on that testimony so that they could introduce the 404B evidence, or do you?
No, I don't think so, but I think it was a hook that they then tried to use. And to be very clear, while we think that the marginal probative value of this was quite low, if anything at all, when you look at the other side of the balance, I think the prejudice was significant. I mean, there's no dispute that 404B evidence is always prejudicial. That's the nature of it. There's no dispute that it's even more prejudicial when it's introduced for intent, as it was here in part. And it's even more prejudicial when the other act evidence is similar in nature to the charged offense. That's what we have here. And it was, in fact, almost right afterward in time as well. And to be very clear, the other act evidence in this case was extensive. It was over 60 pages of the trial transcript. That's at JA 172 to 232. These are the last witnesses, and it was the last evidence that the jury heard before closing argument and deliberation and instructions. And I think that the prejudice that it's clear is shown by the fact that the district court's analysis of the prejudice, I don't think the government even defends. The district court's explanation for why there was no prejudice here was that, well, the charged crime involved allegations of 1.5 million in funds, whereas the other act evidence only involved $55,000. And I don't think that's the right way to look at the prejudice of other act evidence. The salient question is, what was the conduct? Was the conduct similar in kind and nature? And we have that here. It was very similar conduct. It was almost just a year or two after the charged conduct. And I think the takeaway from that for any jury would be to focus highly on the propensity evidence.
Can I ask a following question? So if the piece of evidence that we were talking about earlier where a mistake comes up, if that's adduced in cross-examination by defense counsel, not in a direct question that asks about it, but in a question that asks about something else and the witness just volunteers that, would your assessment of the balance here change?
I think it would. I think it would change if that was part of the strategy of defense to on cross-examination. But I think that
No, so let's suppose it's not part of the strategy. It just comes up in cross-examination. Wasn't planned, wasn't intended. It's a question that doesn't directly ask about it, but the witness volunteers it in response to the question.
Your Honor, I don't think it would affect the analysis too much, again, because I think it is directed towards what the defendant is trying to put at issue in his or her defense. And if I could,
Mr. Hicks, let's assume you're right about that. The government makes a pretty strong argument that the error would be harmless. And the evidence is that only Milligan could access the paycheck system, and her supervisor. Her supervisor testified that he never did. She took funds in the name of several employees and deposited them in one bank account completely controlled by her. And then she took steps to cover her tracks. So why isn't this pretty clearly harmless?
well, Judge Tatel, with respect, I think those are very good arguments to make to a jury on a retrial without the aspect that was included.
Well, no, they're questions we ask also.
Well, I don't think this court necessarily, and I think this court is clear, it doesn't step into the shoes of the jury.
No, but you agree that we do apply harmless error analysis to a case like this, right?
Sure, I think
Okay,
I think you're trying to decide whether the government has shown.
Well, that's inherent in any harmless error analysis that we undertake, right?
Yes, but I think also inherent in that is to
I
look
mean,
at.
if as you said, we're intruding on the right of the jury, then we would never engage in a harmless error analysis.
Well, I think what you do is you look at the nature of the prejudice that is trying to be addressed through the harmlessness error. And again, I think this goes beyond the mine run of cases where you've got just sort of mere 404B standard prejudice for the reasons I explained.
Let me just quickly change subjects for you and ask you quickly about the sophisticated means enhancement, which you challenge. Assume that I think we apply a due deference standard here. Just assume that for purposes of the question. What explanation would I give for setting aside the enhancement here, given the evidence of the cover-up? How would I say I wouldn't give due deference to the district court's decision, particularly since the district court, they see these all the time. We don't.
Well, Your Honor, I think that if you're asking sort of what are the reasons that the sophisticated
No.
I'm
not asking that question.
Legal error?
I'm not asking that question. The question I'm asking is, let's assume I agree with you. This, to me, doesn't look very sophisticated, but the district court thought it was, and I owe due deference to the district court's assessment of that issue. So what would I say to set aside his judgment on it?
Well,
How would I explain that I can't defer to him? What's the rest of the sentence? We can't defer to the district court in this case because, what's the rest of the sentence?
I think it would be the same because that you use in your other abuse of discretion cases, Your Honor, which is that this would be finding the sophisticated means here would be beyond the range of a reasonable decision in light of the utter lack of sophistication that was inherent here.
Suppose you just stated the conclusion, the utter lack of sophistication. I mean, sophistication can mean one thing to one person and something to someone else. But let's just, maybe I ask the question this way. Let's assume I thought it was a close case. That is, that you can make the argument either way, sophisticated, not sophisticated. In other words, it wasn't clear one way or the other. Don't I have to defer to the district court on that ground?
Your Honor, I think if it was a close question, I think that then the standard of review would come into play, as you say. Yeah. But I think that when it is not, when the text of the sentencing requirements say especially complex, I think especially means something or especially intricate. I think you have to give some meaning to the word especially And I don't think setting up a different email accounts or going and, getting a PO box, and promptly getting caught is especially complex. I mean, I think I would use
Well, the fact that she
a different,
got
completely
quickly,
different
the
opposite
fact
word
that she
for
got quickly caught doesn't mean it wasn't sophisticated, right?
that.
They're not really related to each other.
Well, I don't think this is a situation where there was some sort of years-long hiding of anything that would be indicative.
Where do you find that standard in the guidelines?
I think that is indicative of something that would be especially complex or especially intricate, fictitious, creating corporate shells. I mean, I think when you look at that and you're trying to determine what sort of thing is especially intricate in a fraud
Well, isn't that
case,
what she did?
She did not create any corporate entities. She did not create any fictitious entities. She just put it, said.
She said there is one. There's
There was a
real
fictitious
estate.
entity.
It wasn't real, but she said it was.
It was
Why
not
isn't that sophisticated?
I think that they're.
So you think the distinction is between the fact that she didn't really set up this realty company, but only called it one on paper? That's the difference between sophistication and not sophistication?
Your Honor, if I had to describe something as utterly not sophisticated, I think it would be this.
Thank you.
Make sure my colleagues don't have additional questions for you. This time, we'll give you a little bit of time for rebuttal. Mr. Hahn, we'll hear from you.
Thank you, Your Honor. May it please the court, Brian Hahn for appellee of the United States. The trial court in this case did not abuse its discretion in admitting the University of Maryland Medical System, or UMMS, evidence. The trial court correctly recognized that under this court's precedent, under Rule 404B, even if appellant had offered to stipulate to the element of specific intent to defraud, that would not prevent the government from admitting this evidence under Rule 404B, so long as it went to a non-propensity issue, in this case, intent or lack of mistake or accident. The trial court also did not abuse its discretion in conducting the Rule 403 balancing in this case and determining that the UMMS evidence, the unfair prejudice of it, did not substantially outweigh its probative.
Where did the district court do the 403 balancing? Essentially said it comes in because it's probative and it was less money. But it never, or maybe you can tell me where, it talked about what the Supreme Court and Old Chief called the relative probative value of adding this other piece of evidence on top of all the evidence that was already in the mix. Where did it do that?
Yeah, so I think that on page 291 to 292 of the July 21st transcript is where the trial court specifically undergoes the 403 balancing. And I think I agree with Your Honor.
Sorry, which day page are you on?
I'm on page 291, the July 21st transcript. And I think I agree with the court that the trial court doesn't specifically say, this is what the specific probative value here is. But the court does recognize that the evidence is of a probative value to intent and lack of mistake or accident.
Sorry, I don't have a 291. My appendix goes up into 240.
In the JA, do you have the JA page?
I'm sorry, I don't have the JA page. I apologize, Your Honor.
Okay, sorry. Remind me which date then, so I'm at the right one.
Uh,
Is it in the, are the pages
in
you're
the
referring to
appendix?
in the appendix?
I am not sure of that, Your Honor, actually, so I apologize. I only have the transcript citation in front of me. But I think that
Read me what the judge said.
I don't have the specific quotation, Your Honor.
We
But
don't have the pages and we don't have the language.
so I don't have the JA pages and I don't have the quotation in front of me. But what the trial court does say is that the defendant, what the trial court does
Looks
say.
like it looks like it's in the supplemental appendix, pages 111 to 112.
Thank you, Your Honor. I appreciate that. I appreciate that help. What the trial court does say is that the government still has the burden of proof in proving intent, that it's also probative of mistake or lack of accident because there was testimony in the case that appellant told her bosses at GMSI when they noticed that there were some payments to David Morgan that shouldn't have been paid out, that it must have been a mistake or accident in terms of, I think what she said was that she had accessed the system in order to, someone had asked her to access the system, and it must have accidentally started the payments over again. And I think that particularly when you're looking at the UMMS evidence, both the fact that it is close in time and that the scheme is very similar to the GMSI evidence lends probative value to it for intent in this case.
I just want to get back to, I understand that argument. I'm trying to get back to whether the district court did the balancing that 403 requires under precedent like Bill Chief. And that is not, does this have probative value and is it too prejudicial? It's because if it doesn't have probative value, it's not even irrelevant, so it doesn't get to come in. So that's not really doing anything on that side. And the Supreme Court spent a lot of time talking about you need to analyze the relative probative value, or what your friend calls marginal probative value. The Supreme Court's words were relative probative value. And so did the district court do that? And if so, where?
So what the district court says specifically is that it is considering the fact that appellant did not, avoided the issue of specific intent in cross-examination, and says that I'm
talking about all the other evidence in the record.
Sorry.
As I read the district court, when counsel for Ms. Milligan said you need to look at marginal probative value, the district court said, no, I don't. That's not the test. So did not seem to engage in this analysis.
I think I disagree, Your Honor. I think what the trial court says is that the trial court does recognize that the fact that appellant did not, make a full-throated defense, did not cross-examine witnesses based on the issue of specific intent, does affect the probative value and might do so in a marginal way, but that it did affect the court's view of the probative. And I don't know of any precedent, Your Honor, that suggests that the trial court needs to explicitly lay out every single piece or factor in the Rule 403 analysis when making its decision. I think that the record just has to reflect that the court, in fact, did do a proper 403 analysis. And I think it does so here because the trial court does, in fact, reference the fact that appellant's way of trying the case does affect what the trial court views as the probative value of the evidence. And then the trial court goes on to view the unfair prejudice. And again, I don't think the trial court explicitly talks about what the unfair prejudice is. I think everyone sort of knows what the unfair propensity prejudice is from 404B evidence. But the trial court says, look, the amount of money that was taken from UMMS is much lower than it's about $55,000, I believe, much lower than the over $1.5 million that was defrauded from GMSI. And therefore, its unfair prejudice is lessened because of that.
Yeah, I'm not sure I completely follow that because the prejudice, it seems to me, the potential prejudice comes not from the amount of the fraud, but from the fact of it. It's that this is the type of stuff this person has done before, ergo, they probably did it this time too. And the fact that last time they might not have gotten as much money, yeah, I mean, you could sort of look at it in some abstract way and said, boy, that troubles me at level A. It might trouble me at level B if the fraud had been even more successful. But really, the work is being done not by the amount that's ultimately gained, but by the pattern of conduct. No?
So I think I agree that there is some unfair prejudice inherent in the fact that the scheme is the same, that the conduct is the same. I think that, as you, just said, that you might care about it more or less, A or B, on those different levels, depending on the amount of money that was taken. And certainly, if we were trying to bring in evidence of the GMSI fraudulent scheme in a trial for charging appellant with defrauding UMMS, I think that the amount of money would affect the unfair prejudice analysis there, because I do think that when a jury looks at the amount of money that's taken, if it is a extremely large amount versus a much smaller amount, I think that does affect the prejudice.
But the jury's sitting there looking at the evidence. Aren't they saying, do I think this person is guilty of the offense? I don't know that they'd say, I think it's less likely the person is guilty of the offense because the last time they did it, they didn't get that much money.
Well, so I think that it's the question is how prejudicial it is in terms of, like, can we attribute sort of bad character to this person, right? It's the unfair propensity inference. And
The propensity to engage in the criminal conduct,
right,
which was engaged in, even if it wasn't.
Yes, but I do
Fruits
think,
born weren't quite as juicy.
yes, but I do think that more serious criminal conduct is more prejudicial than less serious criminal conduct. Is really all we're saying. That's part of what the trial court's analysis was here. I do want to say that even if this court believes that the Rule 403 evidence was admitted improperly, that in this case it was harmless. There was substantial evidence that appellant specifically intended to defraud GMSI. There were many payments made to her bank account in the names of many different employees over the course of several years, and that when her bosses noticed the discrepancies with David Morgan's payments, she engaged in this very sophisticated cover-up scheme in order to throw them off her scent, and allowed her to perpetuate the scheme for additional years. And so I do think that, and in addition, the trial court gave a very detailed and specific instruction on how the jury was to use the evidence. And of course, the government referred to it once and referred to it in conjunction with the instruction that the court gave.
This is kind of the irony, is because under 404, the government's argument is, we need this evidence. And then we get to harmless error and they go, we didn't need it. We had so much other evidence. And that this really wouldn't have mattered to the jury anyhow. And that's exactly the type of upfront inquiry that the district court was supposed to undertake when it did 403 balancing. So it seems like the defendant's kind of in a catch-22 here. If it argues the balancing, and the district court says, as it did, I don't think that's the test and I'm not going to do it, then they're never going to get it overturned because the government's going to turn around and say, we had so much evidence, this didn't really matter at all. How can the government say both things at the same time?
Yeah, so I think two things, Your Honor. First, I would say that the inquiry at the front end isn't whether or not the government needs the evidence, whether it's necessary for the government's case, of course. It's whether or not the evidence is probative and whether or not it's unfair prejudice.
No, it's more than just whether it's probative. That's the relevance inquiry. Well, it is whether it's relative probative value. That is in the scheme of the evidence presented. And that's why the district court wisely waited here until the government had put on, most of its case in chief. And so now I see what you've got. Now I see the sort of semi-truckloads of evidence that you have brought in on this issue and nothing really pushing back from the other side. What is the value of putting this in? And the government there says, we still need it, so that the jury will understand that it really was intent and not mistake. But then you can't turn around at a harmless error stage and go, we didn't need it, it didn't matter to show intent or absence of mistake. That's what I'm wrestling.
Yeah, and I think, Your Honor, again, I would say that the inquiry isn't whether or not the evidence is necessary for the government's case. I think the inquiry
There's a difference between necessary and having relative probative value. That is probative value within additional probative value.
Yeah. Within
the context of the case.
Yes, and I think the
government said at the 404 stage that we don't need it. We've got plenty to win on this record, but we'd like it. And there was prejudice. The district court would almost necessarily abuse its discretion by letting it in if the government says, we don't need it. We'd like to have it just to tie a bow on this. But that's sort of the argument that's made at the harmless error stage.
So I think the additional probative value of the evidence is that it's different in kind than the other evidence that was admitted to show her lack of her specific intent. You've got the evidence of the scheme and how broad it is. You've got evidence of the cover-up. And then now you have additional evidence in the 404B evidence that she did a similar scheme later, about a year later. And then also that when she goes through her exit interview, I'll call it her exit interview with UMMS, that, while she doesn't specifically admit to wrongdoing, she does apologize for what happened. She offers to repay the money, and she offers some sort of reasons why she might have needed the money. Her husband died, her son, she needed to pay for her son's college. And so that, I think, Your Honor, is different in kind and sort of has a different probative effect than the other evidence in the case. And that's why it's admissible under Rule 404B and Rule 403, and still can be, if erroneously admitted, harmless in the context of this case.
Make sure my colleagues don't have additional questions. Yeah, please.
If there are any questions about that.
I wanted to ask about the enhancement.
Of course.
How do you define complex?
I think I would define complex as something that is, I don't know, it's hard to not use the same words, like the guideline uses the word intricate, I think, and complex and things like that. I think that.
Sorry, it says intricate separate from complex.
Yeah,
so
it does.
What does complex mean?
I think complex is sort of like, it's complicated. It is something that is.
It's harder than normal?
Yes. I would say that it's harder than normal.
Right. More, and more maybe thought than normal.
Yeah.
A big stone can be harder than moving a little stone, but this require complex, I think, requires some sort of
some sort of
specialized knowledge or.
Yes.
Okay.
And I think that in this case,
how can there's 2.1 billion Gmail accounts in this world?
I did not know that, Your Honor.
Yeah, billion with a B. How can it be harder than normal and require specialized knowledge to set up a Gmail account?
Yeah, I don't think that is the act in and of itself of setting up the Gmail account, or I think it's a Ymail account, that is the sophisticated means in this case. What I think it is the use of that account to impersonate David Morgan.
That's the fraud.
Well, it's above and beyond the normal fraud, Your Honor. I think this is additional fraud on the bosses of her company in order to try and hide the fact that she has made these.
Okay, so I've made a Gmail account and then I send an email from it. That's
right.
Complex?
She sent emails to them, and then she's represented to them conversations.
But how is that complex? That's just lying. What's specialized knowledge or complexity? Because that's what I'm wrestling with here. There's a standard in the guideline.
Yeah.
And this seems like stuff that, and getting a PO box, oh my gosh, anyone can walk in and do it. So there's nothing complex about the Gmail account or the Ymail account or the getting the post office. And now you say, well, but using them to lie is what made it complex?
Well, and because she has the knowledge that the type of lies that she's telling her bosses will be ones that will cover up the scheme. I think she also
that's just covering up. Is every effort to cover up fraud complex?
So I think that what makes
when you cover it up, that makes it complex.
No, Your Honor, but I think that what makes it complex in this case is the additional steps that she took. You've already mentioned
the additional steps.
So
I'm sorry. Right. So but I think we can agree. I can give you the number of post office boxes in this country if you want, but I don't think it's going to help your case. So. And they're really, really easy to set up. So if it's not the setting up the post office box and it's not the setting up the fake Gmail account.
She sends a promissory note to the GMSI in the name of David Morgan, agreeing to pay back the money.
Why does that make it? I get that she did these things to cover up. Why is that a complex thing to do?
I think the interlocking of all of these separate steps is the complexity.
Interlocking is just covering up.
I don't think that it's.
Okay. Well, I'll give you that it's complex. Now you have to tell me how it's especially complex, because that's the standard under the guideline. Tell me how that is. If we say that's complex, how is it especially complex?
Well, again, Your Honor, I think that based on what we've already talked about, it's especially complex. And I don't know that it looks like you're not going to.
I'm puzzling. I haven't encountered this guideline before, so I'm really puzzling about what they mean by complex and intricate. We can sort of feel our way through that, but then they've got that especially complex and especially intricate, which I think were obviously deliberately put in there as modifiers on how complex and how intricate it needs to be. And that's what I'm really trying, and then, you know, there's no sort of verbal formulation that's given by anybody. The district court just says, well, she created a PO box. She got a PO box. She created this account and used it to pretend to be this person to cover up for fraud in one instance of the frauds that she did. And that's all I saw the district court relying on. And so if I had to write an opinion to explain how that meets the standard of especially complex or especially intricate, that's why I'm asking you these questions. How would you write that to say this is not just more than the norm? That would just be complex. This is way beyond the norm. It is especially, it's beyond the norm of complex. How would you say that?
I think that I would point to the comment to the guideline. I think it's 9B, which says that, among other things, the creation of a fictitious entity to hide these fraudulent transactions.
But she didn't create an entity. She impersonated somebody. An entity is not a person.
So,
I mean, setting up an entity like a whole business or something, that probably does require more complex steps. But just lying and pretending I'm somebody else is not setting up an entity.
Well, she did, set up or at least represent that there was an entity called David Morgan Rental Properties when she registered.
She said it. Did she set it up? Did she set it up? Did she do anything to set it up, or she just said it existed?
So I agree that she did not set up, formally file paperwork with.
Did she do anything to set it up, or just lie?
I don't think that there was evidence that she did anything formal to set it up. But I think that.
Did she do anything informal to set it up?
Well, I mean, she did in fact represent that it existed.
Right. So she lied.
She lied about it, and she created documents that said that it existed.
How would you compare the level of sophistication to what was at issue in McCants?
I think that it is less sophisticated than McCants. I think that in McCants there was more sophistication there. It was across jurisdictions. That was one.
Was this not across jurisdictions?
This was across jurisdictions. It's true. This was across jurisdictions. I think that there
district court didn't rely on that, though.
The district court
didn't rely on it.
Didn't explicitly say that in its decision. That's correct. But
there's no dispute that it was.
There isn't any dispute that it was, though. Well, actually, I think the defense at trial was that there was no venue because, and that
right. Their whole argument was no interstate commerce.
Yeah.
So do we know that that's in fact true?
But the jury rejected that argument, and there was sufficient evidence at the trial for that. That's not being challenged on appeal. So but I do think McCants also says that even if you could imagine more sophisticated means of conducting the fraud, that doesn't mean that what happened in the particular case isn't sophisticated means, that the enhancement doesn't apply. I would say, Your Honor, that, I'm sorry, did you have a question, Judge Tatel? That Judge Tatel, in fact, brought up this point that the standard here isn't, is really, I think this court in Hunt said that it's really a factual finding by the trial.
This is not a factual finding. This is applying there's no dispute about the facts here. This is applying the guidelines to the facts. These facts are not contested, at least at this point. That's why when I asked Mr. Hicks my questions, I asked him, isn't the proper standard due deference?
Yeah,
there's no fact finding.
I think I read Hunt to say that it's essentially a question.
Isn't that right?
I think I read Hunt to say that it's essentially a question of fact. But I think that whether or not that merits a clearly erroneous standard or a abuse of discretion standard, whether or not essentially a question of fact meets that standard, not particularly sure. But I do agree that there is.
Are you arguing with me about this because you don't think you can prevail if it's a due deference standard?
No. I think that regardless of what standard we're talking about, there is deference owed to the trial court, and therefore, that the sentence should be. If there are no further questions from the court, I'd ask that this court affirm the convictions and sentence in this case. Thank you very much.
Thank you, Mr. Hahn. Mr. Hicks, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. Just 3 quick points in rebuttal. First, as to the question of did the district court address relative probative value? And this is I know you have it from the other appendix. I'll give it to you in the JA, which is 130 and 131. That is the entirety of the district court's analysis as to both probative value and prejudice. It's very short, and the answer is no.
Is that the same? Are those the same pages?
I believe they are. It's the July 21st transcript, but if you're looking for JA, it's 130.
Got it. Thank you.
And the answer is no. It did not address the probative value in terms of the relative probative value in light of the undisputed non-disputing of intent and mistake. So we think that is contrary to Old Chief, and the case is saying that you do look at the relative probative value. Second, and as I think I heard the government concede, the district court really didn't engage in a prejudice analysis other than to say, I don't think it's prejudicial because the money just wasn't as much as the first time around. And as we've said, that just doesn't seem like the right way that you approach the prejudice from a 404B of evidence. In addition, again, to all the other prejudice that we point out, that it was introduced for intent. It was similar in nature to the charged offense. It was right afterward in time, and it was extensive. It comprised over 60 pages. And if you're looking for that, it's at JA 172 to 232 is all of the evidence, the 404B evidence at trial. And then the last point I'll make, third, is I believe I did hear the government say that the sophisticated means here was allowed her to continue the scheme. And as we point out at page 40 of our opening brief, that's simple. You can't conflate the two. You can't conflate the sophisticated means with the fraud that is the underlying element. And
I thought there was a reference, that cases refer to sophistication in the execution of the scheme too. Is that not right?
I don't think it is. I'll give you what I think is the best case on this, which is the Fourth Circuit. It's at page 20 of our opening brief. It says, because virtually all fraud will involve misrepresentation, the realm of especial complexities and intricacies involves more than the forgeries, misrepresentation, and concealment inherent in fraud. And I think that case is important to this point, not only for what it says, but it uses that word especially complex, especially intricate. And we're talking here, this added 15 months to her sentence. It increased it from 81 months to 96 months at the 25% increase. And all for something that, boy, sure doesn't seem very sophisticated to me, much less especially sophisticated or complex or intricate.
The government said the promissory note made it complex.
I think the promissory note, if you go back and look at the promissory note, it was the opposite of complex. I mean, it was written.
Well, I thought
it was just kind of.
It's better than that, right? It said the promissory note was done by the company lawyers once she told them that this guy wanted to pay the money back.
But I think
that's what the district court found. So she didn't even do the promissory note.
Yeah, again, it was. I don't think it was the.
So it's hard for it to be complex if she didn't even do it. It's after she said the guy wanted to pay the money back, then the DMS lawyers drafted the promissory note.
Yeah, I mean, I think that I agree completely, and I think that for lack of a better word, the opposite of sophisticated would be somewhat ham-handed, and I think that that does not merit 15 additional months. There are no further questions.
No further questions?
No.
Thank you, Mr. Hicks. Thank you, Mr. Hahn.
Thank you, Judge Tatel.
We'll take this case under submission.
Case number 21-5257, Flores Rights Education Fund, Inc. and Paul Hudson, appellants versus Federal Aviation Administration. Mr. Sandler for the appellants, Mr. Hammond for the appellee.
Good morning, counsel. Mr. Sandler, please proceed when you're ready.
Thank you, Chief Judge, and may it please the court. It is difficult to imagine a case in which the fundamental purposes of the Freedom of Information Act would be implicated to a greater extent than in this one. 2 fatal crashes of the Boeing 737 MAX aircraft cost 346 lives. The original decision by the Federal Aviation Administration to certify that aircraft as safe was manifestly flawed, and numerous official reports and studies showed that that original process was corrupted by conflicts of interest and a culture of secrecy. After grounding the aircraft in March 2019, Boeing submitted numerous proposed fixes and modifications to the aircraft design, and in November 2020, the agency ungrounded the aircraft, found it fit and safe to operate based on Boeing's proposed design changes. Flyers Rights has been trying through its FOIA request to get the FAA simply to reveal the basis for that, the full factual basis for that decision, specifically the certification plan setting out the steps that Boeing was going to take to show compliance, testing methods, flight test plans, the results of those tests, and safety analyses. The record before the district court included the declarations of 7 independent experts, unrebutted by the FAA, that without access to those categories of documents would not be possible. It is not possible to determine whether the fixes submitted by Boeing and relied upon by the FAA actually made this aircraft safe to fly. The district court accepted the FAA's claims that all of this information was Boeing confidential commercial information shielded from public scrutiny under Exemption 4. And we submit.
Can I just ask you, you're not contesting that it's confidential, right?
We do not contest.
You're not contesting that.
Correct.
Correct. Okay. So your argument is that through these public statements, the FAA put Boeing on notice that it would be making them public, right?
There are several arguments.
Well, that's one of them, right?
Right. One of
So what in those statements? There's 4 by the FAA commissioner or administrator before Congress, and then there's 2 Boeing statements by the CEO, right? The transparency statements.
So we think that in this case, the state, we're not drawing on a blank state here.
My question is, what could you point to in those? Start with the FAA statements, the 4 FAA statements that I know they call for. The agency is calling for transparency, but what in those statements suggests that specifically includes or would put Boeing on notice that its documents would be released publicly?
The pledges of transparency were not made generally about agency policy. They were specifically about the ungrounding and recertification process.
Right,
and they were
about the 737 MAX.
What
about the documents? What in the statements would put Boeing on notice that these compliance materials would be released?
The pledge was that there would be full transparency with respect to the recertification process for this aircraft, and it's clear that those statements were deliberately made to draw a contrast with the original flawed certification process, in which a fundamental issue was Boeing's withholding of information from the agency and airline pilots and the public. In fact, Boeing admitted to a criminal conspiracy to withhold information and deceive the agency. We submitted, in addition to the fact that the unrebutted expert testimony that without this information, the public couldn't determine whether the FAA's
okay, but that's not the question before us, right? Even if you're right that without that information, the public couldn't assess it. That's not the question in a FOIA case. The question in the FOIA case, in the way you've set it up, since you've conceded they're confidential, is what in the record suggests that the agency put Boeing on notice that the specific information you seek would be public.
Exactly.
Even if conceding that the public couldn't effectively analyze the effectiveness of the FAA decision without it, there still has to be evidence, correct, that the FAA put Boeing on notice that these materials would be made public.
Exactly.
The question is what in this record did they?
The statements that we cite, because transparency, the pledge of transparency, specifically with respect to this recertification process, would be meaningless unless these categories of documents are released. We submitted.
Well, see, you're back to arguing the wrong point now. It can't be that, it can't be that, it loses their confidentiality because, at least I don't think it could be, that they lose their confidentiality because the public couldn't accurately assess the effectiveness of the agency without them. We still have to answer the question, where did the FAA say that these, or put Boeing on notice, that these materials would be public? You agree that's the question, right?
Right. We basically, the fact that the specificity of the pledges they made with transparency combined with the fact that those pledges would be meaningless without disclosures of these documents would have, we believe, meant that Boeing was reasonably put on notice. We submitted a declaration from experts on that point too, one of whom was a former Boeing engineer, said that, quotes in his declaration in this record, Boeing would have clearly understood that the FAA could not meet its commitment to transparency without making these categories of information publicly available, end quotes. Somebody who had years of experience with Boeing, again, unrebutted on this record. Just some of the other issues raised here, 80 pages of the documents in this case that were withheld were FAA's own comments about Boeing's submissions, about its proposed fixes. We submit those were not obtained from a person, quotes, within the meaning of exemption 4, because the government created those comments, not Boeing. The district court allowed the agency to withhold those because some confidential commercial information could be extrapolated from those comments. But we would submit that's kind of a standard with no limit. At some point, the FAA must have said, this is our view, this is our reaction, and if you can never get that from the agency because you can sort of somehow reverse engineer the confidential information, it would, in a lot of contexts,
The FAA,
that out of the act.
I'm looking at the FAA's declaration. It says specifically that these comments nonetheless reveal proprietary information which was only provided to FAA by Boeing. That's what the affidavit says.
That's what the FAA says, but it's inherently not logical that that nothing that the government said about Boeing's fixes.
Well, how can we? It sounds like what you want us to do is look at the documents. Is that what you want? I mean, we don't normally do that. I don't know. We have a sworn affidavit here from an agency. It's pretty specific. And in fact, it's pretty specific. It's much more specific than in other cases. And I don't know. And the agencies are entitled to a presumption that these affidavits are accurate. So I don't know how we can pierce what she says.
The FOIA requesters are always at a fundamental disadvantage.
Yeah, right. That's the problem with the statute. I agree. That's inherent in every FOIA case. We always have a precise problem. You're at a disadvantage because you don't see the documents and we haven't seen the documents. And all we have is a declaration to go on. So we have a whole bunch of cases that tell us, that all we require is that the declarations be sufficiently specific and rational. And I don't see where you've, in the record, contested any. Other than to say it just can't be.
Well, right. It's inherently not logical.
That doesn't make it.
Every word of that government comments reveals commercial, technical information about the design of the aircraft.
Oh, hold on, can we just hold for 1 second because we've lost opposing counsel on our Zoom feed.
He can hear.
Can you hear me?
Yes.
I can see you.
And you can hear what's going on in our argument.
I can both see and hear you. I've seen myself on the Zoom feed, but I guess you guys cannot see me.
Sorry, I just want to make sure you could.
Yeah, no, please continue. Thanks.
I'll sit whatever time I have.
I had a quick question. You raised the secret law argument. which normally comes up in exemption 5, excuse me, how does the secret law argument work in exemption 4? It hasn't been used there before, so how do you conceptualize how it works here?
Even though the secret law argument was developed and has been addressed only in the context of exemption 5, it is what the Supreme Court made clear in this year's Roebuck case is that FOIA itself, leaving aside exemption 5, requires the disclosure of interpretations and agency statements that effectively embody the agency's effective law and policy. And what we're saying here is that when the FAA allows Boeing to make up its own test to show how they comply with the FAA's requirements and then claim those tests can be kept secret because the tests themselves are proprietary, we're talking about keeping secret agency policy, agency effective law and policy. It affects the rights of Boeing, it affects the rights of the public. I think we would all have loved it if for the bar exam, we could say, I'll make up my own test, and then I'll take it. And guess what? I passed it. I mean, it affects my rights, it affects the rights of the test taker and also the rights of the public that this lawyer is gonna serve. That's why we submit its effective law.
Thank you, Mr. Sandler. We'll give you some time for rebuttal. Mr. Hammond, we'll hear from you now.
Good morning, and may it please the court. Derek Hammond on behalf of the appellee, the Federal Aviation Administration. The question posed by this appeal is the extent to which third parties who submit information to the government can expect the government to maintain the confidentiality of their privately held commercial or financial information. In this case, we consider the confidential commercial information that Boeing Company submitted to the FAA in connection with the certification of a design change to its 737 MAX aircraft. Under FOIA Exemption 4, the government may properly withhold information if it is 1, obtained from a person, 2, commercial or financial in nature, and is 3, confidential. Appellant's primary contention takes aim at this third criterion, whether the information at issue can be deemed confidential. As counsel admitted in this case, though, there is no dispute about the confidentiality of the information. It is under Argus Leader information that Boeing actually and customarily treated as confidential and had been provided assurances of express and implicit assurances of confidentiality when it provided that information to the government. The only dispute in this regard is whether statements by FAA officials undid this confidentiality by vague and amorphous commitments to transparency. But none of these statements expressly vowed to release any of Boeing's otherwise confidential information. Rather, these statements in sum and substance reflect a commitment to work with the independent review bodies that were evaluating the issues that had arisen in connection with the aircraft and to the general concept of greater transparency in the certification process. Nothing in these statements, however, would have reasonably alerted Boeing that the FAA was departing from its decades-long historical treatment of its confidential information. And particularly here, where we are talking about the relinquishment of sensitive confidential commercial information owned not by the government, but by a third party, the bar should be especially high so as to safeguard that information from the intolerable result that such information will be divulged without the third party having a reasonable opportunity to ensure its protection. Because all of the information in this case was confidential commercial information obtained from Boeing, we respectfully request that this court affirm the judgment below. I'm happy to entertain any questions.
Yeah, I just have one question. The briefs, the parties talk about the regulations that are at issue here, but could you just tell us quickly what regulations are we talking about here, and do they include or incorporate by reference means of compliance?
Yes, Your Honor. The regulations
Yes,
can be.
Oh.
The regulations talk about the need to have a means of compliance to demonstrate that a design element meets the regulatory standard. So my understanding is that the regulatory requirements are found in 14 CFR parts 21, 39, and 183.
And you're telling us all they do is set standards. They don't specify means of compliance either within the body of the regulations or by incorporation. You know, there's so many agency regulations that set standards and then incorporate private standards as means of compliance. That's not this case?
Correct, Your Honor. My understanding
Is that right?
My understanding is that the regulations applicable in this case did not have any specific requirement that Boeing show compliance through any particular means. There are, my understanding is that there are a set of publicly available means of compliance that parties may elect to use, but are not required to do so. And Boeing did not do that here. All of the means of compliance that we're dealing with were proprietary information developed by Boeing for this specific purpose.
Yes. No, please.
I wanted to ask you about two documents in particular. One is document 45. One is document 50. Where the Vaughan Index description there says, and the document is described as the first 45 is a comments list from FAA, from the FAA, their questions and comments. And the basis for withholding is FAA says we withhold this record because it contains technical comments and Boeing responses. And then after that, it just says Boeing objects, Boeing notes, Boeing further notes. But it never says the FAA, which is the one that's supposed to comply with FOIA here, agrees that those things will happen. It just describes Boeing's objections. And we've never said that technical comments alone are going to be sufficient for withholding, right? You need to make the assertions about things being intertwined. And in the Gulf and Western case, the Vaughan Index was much more, didn't just say technical information, it identified the categories of technical information, gave a lot more information, but the only explanation we have for 45 and again for 50 is it's FAA comments and Boeing responses. FAA withholds it because it's technical. And then it just describes Boeing's arguments. Is there any case where we have held that a Vaughan Index description like that is sufficient?
I don't know of a specific case like that. I would also point the court to the declaration as well that should be read in conjunction with the Vaughan Index. First of all, at JA 242, paragraph 45 of the first Cabler Declaration.
Hang on, let me catch up to you. Sorry, the first Cabler one, which paragraph?
Paragraph 45. Starting in the middle of the paragraph, it describes that as required, the FAA made its own determination as to whether Exemption 4 applied to each withheld document or redacted portions of documents. The Aircraft Certification Services FOIA coordinator and subject matter experts determined that the vast majority of Boeing's objections were valid. However, in circumstances where the Aircraft Certification Service disagreed with these objections, the FOIA coordinator identified the disputed redactions to Boeing. In each instance, after consultation with Boeing, Boeing agreed to withdraw the disputed objections and the material was released to flyers' rights. The Aircraft Certification Service segregated and disclosed any information not covered by a FOIA exemption that could reasonably be segregated out and released.
That's also incredibly general language. Right?
There's also more information about what these specific documents entail. If you bear with me for one moment.
Sure.
I think it's
paragraph 37 of the declaration, which appears on JA 239. And I believe, that gives more information as well about the rationale for withholding those documents. It describes that these pages consisted of charts, which provided FAA's comments to earlier versions of the project of the project deliverables to which they were attached, note Boeing's position with respect to those comments, and summarize changes that Boeing made to accommodate FAA's comments. With respect to the remaining 8, and then it goes on to describe the other items.
Right, but there's nothing, Gulf and Western, there was sort of details about, real granular details about, without revealing things, but much more than just sort of labeling things technical. It doesn't even say here they're intertwined. It just describes it has this thing and that thing and the other thing, FAA, Boeing, FAA.
Well,
It
it
doesn't
does.
claim intertwined here, and it doesn't in the Vaughan Index, and it seems
Well,
to just characterize what Boeing said. Why is
then
that?
I guess
Why
I
shouldn't
would.
the Vaughan Index show? I'm sorry. I'll just try to finish this thought
My
for you.
apologies.
Sorry. No. I'm breaking up myself here. So why isn't it the job of FAA in its Vaughan Index to say, not just technical information, but this was about, these were, 12 comments about the MCAS system, 6 about brakes, whatever piece you want to, wheels, something, engines, whatever. And in the Vaughan Index say they were intertwined and can't be released. I don't understand why the Vaughan Index is just supposed to, the FAA says it's technical. And here's Boeing's objections. And then we look at this paragraph here, which is at a very, I take it all as true, but it says that at a very, very 40,000 foot level of what was going on these documents. So the question is, why isn't a more granular description, one reflecting the FAA's judgment about what these documents would reveal, not Boeing's, what Vaughan requires?
Well, Your Honor, respectfully, I believe that the Vaughan, in conjunction with the declaration, and I guess the more pertinent provision that I should have pointed you to earlier is on JA 244. So it's kind of spread out across the declaration. At paragraph 51, it describes that although this kind of technical information is incorporated into FAA authored comments, these comments nevertheless reveal proprietary information originally provided to FAA by Boeing. I think
that's about documents 41 and 83, not 45 and 50. But 45 and 50 is above that in the same paragraph.
Yeah.
The sentence says, these charts contained, well, first of all, isn't that right that the sentence you just referenced refers to documents 41 and 83 rather than 45 and 50?
I don't know that that's correct, Your Honor. I interpreted this as applying to all of the, because both of these reflect FAA comments.
But it's right after a sentence that says, of the 8 pages produced with redactions, the FAA redacted only that information that originated with Boeing. I thought that the 8 pages produced with redactions refer to 41 and 83, because 45 and 50 were withheld in their entirety. But maybe my impression's wrong.
Right.
It could be read that way, Your Honor.
I don't know what you mean by it could be read that way. It's exactly what it says. And if the 8 pages, isn't it true that 8 pages produced with redactions only refers to 41 and 83? That can't refer to 45 and 50, because 45 and 50 were withheld in their entirety.
That's true, but all of these pages deal with FAA comments, incorporate FAA comments.
I just assumed that the last sentence, when it said these comments nonetheless reveal proprietary information, it was talking about the sentence that came right before it. But you still have sentences before that, and I have a question about that. Earlier in paragraph 51, in particular reference to documents 45 and 50, there's a sentence that says, these charts contain FAA comments to Boeing's project deliverables, which in themselves would reveal technical data and Boeing's proprietary methods of compliance if released. Charts also provided Boeing's comments in response to the FAA's comments, identifying actions Boeing took to address the FAA's comments. That refers to 45 and 50.
Yeah. Yes, you're correct, Your Honor. My apologies.
And then on the part that says, which in themselves would reveal technical data and Boeing's proprietary methods of compliance if released, without getting to the level of generality at which that is with the point made by Judge Millett. I just want to make sure that when it says which in themselves, that's talking about FAA's comments.
That's correct.
It's not, because it says these charts contained FAA's comments to Boeing's project deliverables, which in themselves would reveal, which I guess the question is whether that which in themselves refers to the FAA's comments, or does it refer to Boeing's project deliverables? And I read it to refer to FAA's comments, but
Yes, that's correct, Your Honor. It refers to
Okay.
the FAA comments.
okay.
But what about the technical data? Why is that? Again, in Gulf and Western, right, we were able to list the types of technical data. Scrap rates, break-even point calculations, actual cost data, right? It wasn't just simply saying it's technical, we can't talk about it. Because there are a lot of technical things about these airplanes that are also going to be known to the public, known to at least countless other people outside Boeing and the FAA, especially given all of the studies and reports that were done on this. And so why is just saying it would reveal technical data? I get your proprietary methods, but it seems to draw a distinction between technical data and proprietary methods.
Well, the only technical data that was withheld also was that which is maintaining confidence, not technical data that was otherwise known to the public.
So all the technical data is proprietary. Are you just
That-
saying the methods of compliance are proprietary and the technical data is also proprietary?
that all of that
It
which was
just it
withheld.
reads. And so after Gulf and Western, we're not going to require any more. It's just enough for an agency to say it was technical data. And so therefore it's privileged.
Well, I mean, there's more to it than
Even if
just
it's about
saying,
the outside of the airplane that anybody walking by can see.
yeah, but
That-
Where are the engines located? How high off the ground are the engines? That's technical data.
yes, but they're not withholding information that is otherwise known to the public, and I think that's what the declarations in this case speak to. That they did undertake an effort to segregate out any information that is not covered by exemption 4. And
Is the technical data, and I just want to make sure I get the response to Judge Millett's question. Is the technical data proprietary information?
Yes, it is, because it deals with the technical details, this technical specifications that Boeing, not only technical specifications, but also I think perhaps, I don't know specifically in this instance, but all of the data that we're talking about here generally deals with the technical specifications of the aircraft, or information that could lead someone to discern those technical information, that technical information, and that is information
Which is
that
proprietary.
which is proprietary and held by Boeing in confidence.
There's a problem here that we're adding words into this declaration, we're adding words to the Vaughan Index and the declaration that aren't there. Is that a problem?
I'm sorry, which words are you?
Proprietary technical data,
Sure.
private, undisclosed technical data, non-public technical data, because, one of the issues was the location of the engines, which, is technical data for sure. And people can tell that by looking at the outside of the airplane. I can't imagine that's still considered proprietary. It's
But
just,
how all of
it just feels, what I worry about, I'm sorry, just to lay on the line, and I apologize for interrupting you. What I worry about is sort of cookie cutter language in Vaughan indices and declarations, and that doesn't contain the type of detailed information our prior cases like Gulf and Western have had. And so we're slipping on this. And so then there's really no way to make sure that, that people dealing with a lot of information, very busy people, have looked at these things with the rigor that's needed. If they're, they haven't sworn declarations that say exactly what they want, what we now want to assume that they meant.
Sure. The one other point I guess I would mention is that these documents, I mean, the one document I think is 78 pages long, it's quite sprawling, and covers, and I believe it covers quite a bit of material. But obviously that's not in the record, but just to provide maybe a little more context here. And I don't know, I mean,
I'm sorry,
the
can I
case,
clarify?
I think the case law requires, for them to reasonably describe the information without revealing the information. And in some cases, I don't know how they would describe what the technical information is without perhaps revealing what the technical information is or what the proprietary information
Do we
is.
know that was the problem here, that they couldn't say anything more? They couldn't say, as they did in describing Boeing's response, or in the beginning, that these were about, Boeing says it's going to be about MCAS. I hope I'm MCAS or whatever you call it, and speed trim lights. And that's all, right? That they don't give, Boeing will say that, but we're not, the FAA just slaps on the label technical information. It feels to me like this case would be to rely just on the fact they've said technical information. And they haven't said we can't be any more specific. The FAA didn't say that. And so we're moving our case law one step further in the direction of less information in Vaughan indexes and declarations. Now, maybe there's a good reason in this case, that's your position, but we're certainly moving the law one step further to even less information being disclosed and less ability on the parts of courts to ensure, without requiring in-camera review every time there's a FOIA case, to ensure that in fact everything's been disclosed that can be disclosed.
Yeah, I take your point, Your Honor. I do think the trick, as I mentioned, in every FOIA case, to be honest, is how do you describe the efforts to segregate information and why no more information can be disclosed? Because they do that here. But how do you do that without revealing what the information is?
Mm-hmm.
And doing that at a reasonable level, right? You don't have to reveal information that is nonsensical or meaningless in that effort. That would just entail too much agency resources, and it's not reasonable.
Can I ask one question that ties some of this together? On paragraph 67, page 249, the declaration says, and this is dealing with segregability, but however, the majority of the pages of responsive records have been withheld in full. As explained more fully above in section 2 of this declaration, the withheld documents consist almost entirely of Boeing's proprietary technical data and the proprietary methods of compliance. Does that mean that the technical data that was referenced earlier is proprietary?
Yes. That's what they are. That is what I mean when I say that they are only withholding the proprietary technical data, the confidential technical data, and items that are already publicly known are not being, would have been disclosed.
That was part of a segregability discussion, and there was no segregation of information at all for these documents. It was a total withholding.
For these charts,
we shouldn't take anything of the fact they didn't call it proprietary technical data here.
That they did in the Vaughan index for these specific charts,
where they weren't undergoing a segregation process, right?
Yeah,
because there was no redaction.
Right. They attempted to segregate to the extent that they could, and if information, like they said, they did a line by line review, and to the extent that information could have been disclosed, they would have done that.
So how would we write an opinion that would, or can you tell us, or maybe you can point us to something in the declarations that would assure us that anything beyond using the phrase technical data would itself reveal? Because there's lots of times that there are references to categories of technical data throughout these documents. But for these documents, how do we know they couldn't have said anything more than technical data without revealing? That seemed, if I understood your argument correctly, that seemed to be your concern. And we are in a highly technical area here, I get that. How do we know, or what's the best part of the declaration? Maybe it's the part that Chief Judge Srinivasan just read, that even saying anything beyond technical data, even giving sort of categories, this involved the MCAS system. This involved the engine location. or size. This involved, redundant protective measures in the engineering system or electrical system. How do we know they couldn't say anything more?
I think paragraph 67 is the best evidence that's true.
Okay, thank you.
Thank you, Your Honor.
Thank you, counsel. Mr. Sandler, I'll give you 2 minutes for rebuttal.
Thank you, Your Honor. A couple of points on this. With respect to this issue of the documents that Judge Millett and the Chief Judge were referring to, so it's clear, it's correct, nothing was disclosed about those charts. In the Gulf and Western case, the court held that specific cost numbers, cost calculations that were quoted in the documents at issue could be withheld. We could extrapolate it because they were quoted in those documents. We are not seeking to hear the actual technical proprietary information. In that chart, there would be a column that Boeing says, here's our design that we're submitting. The FAA's comments would have to say something like, yeah, this didn't work because the pilot still couldn't do X, or this thing still couldn't be operated. That's not the idea that you can extrapolate technical information from that. That's why we suggest, again, the disadvantage of not knowing anything, the details of the documents. It doesn't make sense that 100% of FAA's own comments, that column in the chart, this is our view, this is what we found wrong, reveals the patented or proprietary, which patent is publicly disclosed, but the proprietary design of the aircraft fixes that they're submitting. And then just to Judge Tatel's question about the regulations, the regulations basically allow, but do not require the manufacturer to use publicly available means of compliance. Instead, again, they allow the manufacturer to make up its own tests, by contrast with regulations, say, for the Food and Drug Administration that say, here's the criteria for the test that you have to follow in order to prove a drug safe. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 22-1146 et al. Fore River Residents against the Compressor Station et al. Petitioners versus Federal Energy Regulatory Commission. Mr. Hayden for the petitioners, Mr. Fish for the respondents, Mr. Marwell for the respondent interveners.
Good morning, counsel. Mr. Hayden, please proceed when you're ready.
Sure. May it please the court. Madam Clerk, Your Honors, Michael Hayden on behalf of the petitioners, and with me also is Town of Braintree Town Solicitor Crystal Huff. This is my first argument before this court. It's the second visit I've made to this courtroom following a 2018 visit on this same matter, where I filed a intervener's brief. Judge Millett and Judge Tatel were on the panel. And given the circumstances described by Chief Judge Srinivasan concerning today's retirement, it's an honor to be back and arguing before this specific panel. The petitioners in this case are 2 municipalities, 2 citizen groups, and 2 individuals. The intervener, Algonquin Gas Transmission LLC's brief notes that the Atlantic Bridge project is a $627 million expansion of certain interstate natural gas pipeline and related facilities. The petitioner's challenge in this matter pertains only to a single facility associated with that project. The natural gas compressor station located on a peninsula in Weymouth, Massachusetts, which does have some historical significance. It's actually the location of the second oldest settlement of the English settlers, the Wessagusset settlement, which was settled in 1622, 2 years after the Plymouth settlement was settled. This natural gas compressor station facility was shoehorned into this $627 million project where it never belonged. And what's worse, the gas company that built it touts a different electric motor-driven compressor option in its company literature that is emissions-free. There was no environmental impact statement prepared by the commission in this case. Rather, an environmental assessment was prepared, which evaluated the electric motor-driven compressor option and rejected it, ironically, on the grounds that it would take too long to build back in 2015. Two extremely frustrating developments to the petitioners form the factual underpinnings for this consolidated appeal. First, Congressman Stephen Lynch wrote a letter to the commission in January of 2018, noting that the deadline for Algonquin to complete construction and place the compressor station in operation was arriving 1 year later in January 2019. And Congressman Lynch asked the commission not to extend that 2-year deadline. The commission responded in March of 2018 by advising the congressman that no request had been presented to it, and therefore there was no extension request for the commission to consider at that time. And yet, just a few months later, on December 26, 2018, the commission circulated to its distribution list on the morning after Christmas a letter request by Algonquin to extend the 2-year deadline to complete construction and to place this facility in operation. Within 34 minutes, the commission posted an approval of that request for a 2-year extension in a letter order signed by Richard Foley, Chief Certificate Branch 1, approving that extension the same morning that the request had been filed. There's no evidence in this record that there was any subdelegation confirmed to Mr. Foley, and there's certainly no evidence of what, if any, consideration Mr. Foley gave to that request.
So our decisions contemplate that no matter what one might say about those kinds of questions, that the commission in full can ratify the decision in a way that then precludes the kind of challenge that you've made in your briefs and it sounds like you're making now. What's your response to that?
Thank you, Chief Judge Srinivasan. The response to that is the commission abused its discretion and exhibited a complete and utter lack of reasoned decision-making in ratifying how that letter order was issued the morning after Christmas.
Did you make that argument in your brief?
Yes, Judge.
Where, in response to the question that the Chief Judge does ask about ratification?
Yes, so the distinction that I'm drawing here, and thank you for both questions. The distinction that I'm drawing here is not that the commission, upon independent grounds, having conducted a full inquiry of whether a 2-year extension was warranted. That's not what happened here. What the commission said, the commission actually explained that even though the 34 minutes looked suspicious, that the commission was aware that the deadline was approaching and that the employees of the commission were actively considering a 2-year extension before the request was even made. That's the explanation for why the 34 minutes was not too short a period of time. But that explanation is completely belied by the response that the commission gave to Congressman Lynch. When Congressman Lynch wrote and said, I see this deadline coming, I want this commission to focus on the potential harm that this facility will have on my constituents, the commission didn't write Congressman Lynch a letter explaining, we're aware that the deadline is approaching, we need to have this discussion. All the commission said to Congressman Lynch was, no request has been made, there's nothing for us to answer here. And so the abuse of discretion and the lack of reasoned decision-making is not by articulating an independent and separate basis for why this extension should have been granted. I would agree that would be a much more difficult case for the petitioners to appeal. What the commission has done is they've sought to ratify this 34-minute decision-making process without evidence of subdelegation. And it's the threat of this court's affirmance that 34 minutes is okay for all future extension requests that should be gravely considered here, because it's not a question of whether under independent review the actions of the commission can be justified. The commission has sought to ratify this ill-considered, completely rushed 34-minute decision, which provided all parties in this action with absolutely no notice.
The commission didn't just sign off and say, we're good with the 34 minutes. It made its own determination that there was good cause for an extension. It made that its own decision. And so, and I haven't understood your briefs here to dispute that independent finding of good cause. So there was good cause at that time on December 26th to grant the extension. You don't contest that.
Well,
Have you in your brief contest? You may personally, but in your brief, in your blue brief, I didn't read you and tell me if I'm wrong, to have contested that the reason the good cause cited Algonquin's efforts to obtain permits and its inability to do so and just sort of drawn out litigation processes is arbitrary and capricious or lack substantial evidence.
The way I would answer that, Judge Millett, is the petitioners can agree to disagree with the commission as to whether that separate review is appropriate or not.
Mm-hmm.
But yes, I don't have the evidence to submit to this panel to explain why an independent review of the 2-year extension request would have been an abuse of discretion.
Okay.
The challenge that we raise is that they packaged together a ratification of the 34-minute approval so that for all future proceedings, that still is available to the commission. And much of what the petitioners have done in
It's
their...
only available to the commission. I mean, one, the commission said it was changing its processes, which I haven't understood you to challenge that to be true. So that would take care of some concern. And two, as long as the commission gives lawfully proper or appropriate explanation and finding of good cause that is unchallenged, what is the harm that you're concerned about going forward?
The precedent that this ratification has set. Much of what the
How does
petition-
that injure your clients?
Well, the injury is that the approval was granted on the day after Christmas without my clients having any opportunity
And then they had
to
full
present their case.
opportunity at rehearing and their arguments, and they made submissions and they were heard, and a decision was made that is not challenged. So what, after the commission's rehearing decision, how are they injured by, well, we just don't like you smiling upon a 36-minute or 34-minute approval process?
Understood. So the injury and the convenience of this consolidated appeal is that both segments, both factual underpinnings, go together. What should have happened, and the injury sustained by my clients, the way the commission handled this extension request, as is evidenced by the letter written by Congressman Lynch, is there was not a full and open opportunity to present the environmental justice concerns that this community had from day one, continues to have to this day, at that moment where the 2-year extension was being considered. There should have been a complete...
But you were able to make all that presentation to the commission in your rehearing petition.
And we have...
And you did in your rehearing petition. So, right, today, how are they injured?
Today, we are injured because there has never been any substantive environmental justice review ever for this project.
That sounds like attack on the certification order.
Well, and I do want to be careful about that so as not to mount a collateral attack.
Mm-hmm.
So the certification, the certificate order was presented to this court. It was affirmed in 2018. That's completely understood. What's happened since that time is that there has been a material change in the core circumstances surrounding the authorization of this facility. The material changes include the COVID-19 pandemic, the Attorney General's report written on the overly adverse consequences the pandemic has had upon environmental justice populations in Massachusetts, and the 3 unplanned emergency gas releases that occurred that triggered a PHMSA corrective action investigation. And
Did you raise all of those to FERC in rehearing?
yes,
Okay, and then they ruled and you haven't challenged it. So again, so you've you've raised all that. You've had your day in FERC court, as it were, to make those presentations. And they were made, and FERC heard them, but FERC drew a different conclusion from the record that is unchallenged here. So I'm asking again, you said our injury is we never got to do it, but then you said we did get to do it. So now that FERC has ruled, has heard you, you've said everything. And then there was that whole other order on briefing. I mean, you've had rounds of saying everything you wanted to say to them, but in particular, after the rehearing on the extension request, I'm still struggling to understand what the injury is.
Thank you, Judge Millett. And the injury is after the second round with the order on briefing and the opportunity to submit supplemental briefs, which is the second factual underpinning for this appeal, FERC 1 year later actually issues its updated policy statement. And that's in Joint Appendix 4. And it draws all these new policies that say the impact to an environmental justice community alone is sufficient for the commission to deny a ruling of public convenience and necessity for all future project applications. So everything that we've argued in this case for every new project going forward is grounds for the commission to rule that this compressor station should not be authorized. And the thought that our clients have to live and breathe and work and recreate immediately in the actual physical space with this compressor station for the next 50 years as it operates 24 hours a day, 365 days a year, that is the harm. They have never received the due consideration that they are entitled to as environmental justice communities, even dating back to the 1994 executive order, which requires this for all commission projects. The only conclusion that the environmental assessment reached was what there would be temporary benefit to the local community with additional jobs during construction and tax benefits resulting from the compressor station.
Let me just interrupt you. I hear what you're saying, and I've read your briefs, and there are members of the commission who agree with you that this was not FERC's finest hour. But let me just ask you, I don't mean to be technical about it, but this is the way we look at issues like this, okay? So take the issue about your claim that the branch chief lacked authority, right? That's one of your arguments. As the chief judge pointed out, in the FERC's brief, they said, well, the commission ratified that, and it relies on our opinion in Murray Oil. And then in the reply brief, I didn't see any response to that. So to us, that's a waiver. Not a waiver, but that issue is done. You didn't respond to the commission's ratification argument, relying on Murray. Same thing with your argument that the branch chief's order was arbitrary and capricious, right? Again, the respondents say, well, we have the petition, the commission's the denial of rehearing before us, which directly responded to all of your arguments. And again, and they relied on Murray, and again, you didn't respond to that in the reply brief. So when I look at that, I think, okay, these issues we're done. That's it. You didn't respond to the commission's arguments.
Thank you, Judge.
What's the matter with that?
Thank you, Judge Tatel. I'd like to address that if I could.
Go ahead.
In the 8 years that my clients have been opposing this compressor station, we've achieved a number of Pyrrhic victories. We have a new Massachusetts environmental justice law that does not apply to this station. It's the same here. Through our advocacy, FERC now has an updated policy statement that will protect future environmental justice populations. We're very happy with that development. We don't rest there. We are seeking environmental justice review for my clients and a Pyrrhic victory in vacating the ratification of the 34-minute approval of the 2-year extension to remand back to the commission for purposes of potentially rubber stamping what has already happened. And I recognize that with Chairman Glick's, the lack of the Senate confirmation hearing, now the commission is down to 4, inviting deadlock going forward. I recognize it is a mountainous uphill climb for my clients to expect any change to occur before FERC. So we don't expect it to happen voluntarily. It is only going to happen through the influence of the courts. And even if everything that you've described, Judge Tatel, means that our victories will be Pyrrhic in nature, we still implore this court to consider them.
Can I ask you, a lot of what we talked about this morning is on 22-1146. I think that's where a lot of the questions come up about ratification in the 34 minutes and the subdelegation. On the other petition, 1147, the commission and the interveners make the argument that there's no jurisdiction to consider that because you only identified the order being challenged as the rehearing order in 2022, not the 2020 authorization order. And that's the one that should be identified as the one that you're challenging for purposes of jurisdiction, because if you were challenging the 2022 rehearing order alone, I think there's some law that indicates that you would have needed to have sought rehearing of that. And then in your reply brief, in a couple of places, you specifically say you're not challenging the 2020 authorization order. And you say that at footnote 1 on page 5, and then on page 6, and then on page 7 again, clarify that you are actually not challenging the 2020 authorization.
Correct. May
Is
I
that
respond,
true?
Mr. Chief Judge?
Yeah, I guess my questions are A, is that true? And I take it that it is because you're saying that. And then B, if that's true, how do we have jurisdiction?
Understood. So unequivocally, we are not challenging the September 24th, 2020 authorization order. Our view is that to do so would have been mounting a collateral attack on this court's affirmance of the original certificate order. So that is not our challenge. What flowed from that September 24th, 2020 authorization order, we did submit petitions for review to the commission. And since that time, in September of 2020, that's when the 2 unplanned emergency gas releases occurred, which prompted the commission to issue its separate briefing order, which I agree with the commission. There was no prejudice to my clients by the briefing order because it invited the very discussion we've been begging the commission to have for 8 years. So there's no prejudice from that. It is the subsequent February 21st, 2020 order on briefing that has prejudiced my
2020 or 2022?
22. Thank you.
Okay.
Thank you. My apologies. It's the order on briefing that responded to the briefing order that has prejudiced my clients, because in considering all of our arguments that the materially changed core circumstances, the COVID-19 impact on the environmental justice communities, and the complete and utter lack of any substantive environmental justice review ever for this project, the commission had the opportunity in writing the order on briefing to address those issues. And it was a borderline apology, such as we're sorry you feel that way, because what the commission wrote in its order on briefing was, we recognize, and this is at page 15 of that order, paragraph 22. We recognize the legitimate health and safety concerns associated with the siting and operation of the Weymouth compressor station, together with the petitioner's allegations that outreach and engagement with affected environmental justice communities was insufficient.
That's an order denying rehearing, right?
No.
2022 order? No.
That is the 2022 order on briefing. So that was the response to the briefing order. The terminology is very duplicative, but we had the 2021 briefing order and then the 2022 order on briefing. And I was reading from the order on briefing at paragraph 22, which is page 15. If a citation to the appendix would be helpful, I can find that in a moment.
Yeah, that was still part of the rehearing, right? They had 2 headings in this.
Right.
They were doing 2 things. Section, you see from page AA 1375. So section A is response to arguments on rehearing. And then on 1380, they start a new section there when they're responding to briefing order arguments.
Okay.
And so the paragraph 22 is part of rehearing.
Okay. Thank you. Thank you. So same document, different section.
It seemed like they were doing 2 things. Well, it's a little confusing, and
Right.
you can tell me if you have a different understanding.
No, that is consistent. Thank you. Thank you for that clarification.
But if it's then you did not need to seek reconsideration of the denial of rehearing?
No, because the briefing order itself, so the briefing order of February 18, 2021, invited all interested parties to comment on 4 categories. Those 4 categories were, in light of the concerns expressed regarding public safety, is it consistent with the Commission's responsibilities under the Natural Gas Act to allow the Weymouth compressor station to enter and remain in service? Question number 2, should the Commission reconsider the current operation of the Weymouth compressor station in light of any changed circumstances since the project was authorized? For example, are there changes in the Weymouth compressor station's projected air emissions impacts or public safety impacts the Commission should consider? We encourage parties to address how any such changes affect the surrounding communities, including environmental justice communities.
So you're on the A part.
That was from the briefing order, yes, Your Honor. And it's in response to that question that my clients reiterated their years-long argument that environmental justice review needs to begin, not be revisited, not questioning something that was done before. It needs to start. It never started. And the only response to that we got was former Chairman Glick issuing the devastating comment that my clients read, which stated, in my opinion, the Commission likely erred in citing the Weymouth compressor station where it did. That was in his concurrence. My client's reaction was, we won. And of course, they very much did not. So
Let me make sure I don't have additional questions from my colleagues.
No, I'm done.
We'll give the Commission a chance to argue, and we'll give it a little bit of time for rebuttal.
thank you very much, Your Honors.
Mr. Fish?
Mr. Chief Judge, and may it please the court, Jared Fish for the Federal Energy Regulatory Commission. I'd like to begin with a couple of jurisdictional points across the two cases, if I may, that go to Your Honor's questions. First, it is true in a case number 22-1147, the authorization order proceeding, the petitioners did not challenge the aggrieving order. And a petitioner must challenge the aggrieving order under Section 717R of the Natural Gas Act and this court's precedent in the City of Oconto in order to preserve their right to seek judicial review. And there is no response to our argument in petitioner's reply brief that petitioners failed to challenge the aggrieving order here. And even if this court were to somehow deem the 2022 order to be an aggrieving order, which it is not, it merely sustained the authorization order from 2020. You're correct, Mr. Chief Judge, that petitioners had to seek rehearing. Section 717RA is clear. A party that seeks to challenge an aggrieving order must seek rehearing before the commission before it may petition for judicial review. So that takes, there is no jurisdiction to hear.
Our rule is clear. I really do get that. But what this briefing decision, order on briefing decision is anything but clear. They try to sort of categorize things into rehearing and order on briefing, but then they insist they never reopened anything. And yet, from their perspective, this was their shot to really tell the story about why this thing shouldn't be allowed to sort of continue operating because of all the mistakes that were made. The commission essentially said in the paragraph he cited, yeah, we screwed up. Rehearing denied. And and for them to, it's such an unusual animal. Even some of the commissioners thought it was quite an unusual or not improper animal. Such an unusual animal what this round 3 was. I feel like it's a little unfair to put on them not to know how to challenge it, because on the one hand, you're not disputing the original motion to authorize the plant to come online, because the usual rules for that, the boxes were all checked and it had complied with everything it was supposed to comply with, and it should come online. And we hadn't had the blowdowns at that point. And so they're like, no, what we're really upset about is this hybrid, whatever it is, decision on briefing, where they essentially said, come to us, tell us about your concerns. And they agreed with us that we were right and nothing happened.
I don't think
they're supposed to know that they have to do another rehearing on this thing that was called already an order on rehearing. It's just awful. It feels, I credit FERC for having done the work and confessed its need to change going forward, but I fear the technical real people are getting lost in the technicalities of all of this.
I understand the concern, Judge Millett, and I also understand that this was kind of an unusual animal, but that we have to look at what petitioners were actually arguing. In their rehearing request, they did raise the blowdown events. They did address COVID-19. They did address environmental justice concerns, which are the very issues they are raising here. The problem is what they sought for the commission to do was to use its Rule 716 to reopen the certificate order record. And that is simply not something that the commission can do once the 6-day period to challenge the certificate order had passed. And more importantly, once this court in its 2018 Town of Weymouth decision decided finally that the certificate order and all of the environmental reviews thereunder were lawful. So at the end of the day, the briefing order was a way for the commission to assure itself it had all the information it needed to issue a reasoned decision on rehearing to determine whether it should revisit the authorization order from 2020. And it acknowledged that all those briefs that were submitted in response to the briefing order would be made part of the record. That's precisely why at footnote 53 of the 2022 order, it's at JA 1377, the commission explained that petitioner's reopening claim, which is the only claim they have here that's jurisdictionally preserved in the authorization order proceeding, that claim was moot because the commission did state in the briefing order it would make any submissions part of the record. And critically,
Why is it moot? Why isn't it actually a reopening? I mean,
Sorry, Your Honor?
why is it moot? Why isn't it actually? Why wasn't this order on briefing a reopening? Because it asked for not just rehearing briefs, it asked for evidence. It asked for factual information. So why aren't they right to understand this for all practical intents and purposes? However, the commission labels its headings within its decision. When you ask for new evidence, new briefing, arguments about events that post-date the facility coming online, that it's not a reopening. How is it not a reopening?
Well, that might have been a reopening for purposes of considering the authorization order. So the time between when the authorization order was issued and the time that the commission issued the 2022 order, that's very different from seeking a reopening of the certificate order record, which is something that the commission said explicitly in the 2022 order it could not do. It was accepting arguments on the blowdown events, COVID-19 impacts, environmental justice impacts. All of those events did post-date the certificate order. But the key here is those events were relevant to the determination on rehearing to determine if Algonquin was out of compliance with any of the conditions on the certificate order itself. And so the commission found at paragraph 16, 24, 25 of the rehearing order, or I'm sorry, paragraph 17 to 19 of the rehearing order, that's JA 1377 to 79, that there is no allegation that Algonquin was out of compliance with its air permits, no allegation it was out of compliance with its PHMSA, Pipeline Hazardous Materials Safety Administration regulations, or any other condition of the certificate order. And because the condition precedent to the continuing operation of the compressor station is continuing compliance with the conditions of the certificate order, the commission found no basis to revisit the authorization order. But
Yeah, so that's the kind of ironic thing here is that the commission found, and I don't take them to dispute, that Algonquin was in full compliance with the certificate order. And so, of course, the authorization order is fine. What we have here is a decision where this says Algonquin was in compliance with the law. It's the commission that was not. And that's what they said. We said we didn't do it right. We didn't, and we're going to change it going forward. I think it's more than this wasn't our best work. I think they say we didn't do it right.
Well, we're changing our procedures going forward. I think that's, we created an Office of Public Participation to engage with environmental justice communities earlier. I don't think that procedural revision necessarily means we got it wrong substantively. Yes, there are Commissioner Flick's concurrence.
Well, I'm not saying for sure that adopting this new office and this new approach suggests anything was wrong. you're absolutely right. We wouldn't do that. It's their sentence that petitioners' allegations that outreach and engagement with affected environmental justice communities was insufficient. They mean legally insufficient?
I'm not sure, Your Honor, but that wasn't something that the commission could reconsider, as the commission stated in the 2022 order anyway. So, commissioners' statements in a subsequent order that, I, Commissioner, whoever, personally feel that we should have come out differently, that's not expounded upon because the commission, as a legal matter, could not go back and reopen the certificate order proceeding, which already addressed the issues of environmental.
But it could have said we shouldn't have, no, maybe it couldn't have. Tell me this. Could it have said we shouldn't have authorized operation? Or could it not have, because the only requirement for authorizing operation is whether Algonquin did things right, not whether the commission did things right?
Right. The condition precedent to authorizing operation is compliance with the conditions in the certificate order. That's where the certificate order has continuing life, because the conditions, once the project is approved for construction and operation, that's done, but as continuing life because the conditions on it, especially the environmental conditions in Appendix B of the certificate order, and need to be complied with. That's what the commission means when it said it has a continuing public interest obligation to ensure that the compressor station is operating in a way that was contemplated by the certificate order itself. But that's very different from suggesting that there was a legal right to go back and reopen the certificate order proceeding. If I could turn to 22-1146 briefly, the extension order proceeding. Judge Millett, you asked questions about what petitioner's injury is. I think that sounds in standing. I would submit that the commission administratively resolved any possible injury that could have derived from A, subdelegation, and B, the 34-minute decision by more than 1 year later having the full commission vote and ratify the good cause determination in the original decision. And I think it's really important. Petitioners nowhere challenge our good cause finding that Algonquin was trying to get wetlands and zoning ordinance permits from Massachusetts. It couldn't, that our branch chief was monitoring that situation, was aware of the reason for the delays, and so was in a position to render a determination on Algonquin's extension request upon receipt. It would be a different matter as far as standing is concerned if petitioners actually were challenging the good cause determination.
Okay. Thank you, counsel.
Thank you, Your Honors.
We'll hear from interveners counsel now, Mr. Marwell.
Good morning, Your Honor. Jeremy Marwell for the industry interveners. Just a few quick points, and I'm happy to answer questions. First, I do think there was some questioning about reopening and the record. I do think it's important to maintain the context that this court is often called upon to adjudicate a challenge to the original certificate authorizing the construction and operation. Here we have challenges to implementation orders, and so there would be kind of overlapping records, but the principle of finality for the original certificate that authorizes Algonquin and other companies, to invest huge sums of money, that is a very important principle, and I think it's reflected in FERC's order. Second, as to the case 1147, putting aside the various threshold questions, I think the reality is the commission undertook an extensive additional process that allowed it to consider all of the petitioner's concerns with regard to post-certificate events. And as the commission said, the commission specifically found there were no violations of the certificate order, no violations of the air permit, no violations of the PHMSA regulations that govern safety and operation of these facilities. And I don't take petitioners challenging those points or really the commission's broader findings with regard to why there was no basis to set aside the authorization order. And then finally, as to the question of aggrievement and what petitioners might have needed to do. I understand aggrievement in the statute to be tied to the concept of standing, and I understand petitioners' claim of standing here to be they're concerned about the operation of the station in that community. That we were authorized to do that by the 2020 order, which petitioners have made clear they are not challenging in court. So if there are any further questions, I'm happy to answer. Those are the key.
Do you, on 1147, you went to the merits, and do you think that we should go to the merits?
Oh, I'm sorry if I was not clear. When I made the point about aggrievement, that's what I understand to be the primary jurisdictional problem there, that they didn't name and they've now disclaimed any challenge to the 2020 order. So I do think that under City of Acanto and the Natural Gas Act, what they should have done is named, not my client, but I think what they could have done and what they did in the 1146 case was to name both orders. They named the in-service authorization, the 2020 authorization, and the 2022 order that was both an order on rehearing and an order that went beyond a typical order on rehearing. And I think that's the statutory jurisdictional problem for them. But I take Judge Millett's point that this was an unusual sort of extra procedure that the commission did. And so that's why I went to the merits of the courts. Thank you very much.
Thank you, Mr. Marwell. Mr. Hayden, we'll give you 2 minutes for rebuttal.
Very much. Bringing everything to this court's attention, there are still 3 matters being held in abeyance. Those are docket numbers 21, 1155, 1138, and 1153. Those are challenges raised by the interveners to the original briefing order in terms of whether the commission had the authority to do that in the first place. But we're not focused on that for purposes of today's proceedings. So the argument submitted by the petitioners is that the commission has opened the door through this briefing order process, which by all accounts is a very unique and unprecedented process. It doesn't seem that it's ever been done before. The next time I have to challenge something of this nature, perhaps I'll throw the kitchen sink at it. But we certainly don't believe that there's been any prejudice that's resulted from the choices of which orders to appeal, because the arguments are understood by all. We agree to disagree on the decision-making that underlaid them, but we do believe that everything is properly presented for this court's consideration. Simply as an aside, the state licenses and permits that are required for the Office of Coastal Zone Management to issue a consistency determination, which is required under the original certificate order, they're still not finalized. The petitioners have been successful in vacating a Chapter 91 waterways licenses in Massachusetts, which has now been remanded back to the Massachusetts Department of Environmental Protection, is going to be scheduled for further administrative proceedings and trial this autumn. And if we are successful there, we would be revisiting the commission seeking to vacate the ability for this facility to continue operating, because then the Coastal Zone Management Certificate of compliance would no longer be in effect. So my clients respectfully implore this court to consider the authority that has been cited by this court in the Vecinos Para L Bienestar decision and by the Fourth Circuit in the Friends of Buckingham decision, recognizing that historically environmental justice communities have been marginalized, underrepresented, and ignored. It is never, ever too late to give environmental justice consideration to the people who are living and breathing and working and recreating near this facility. We respectfully ask for this court to require the commission to conduct an environmental justice review.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Thank you.